Hi everyone, welcome to Workplace TV. Today let's talk about the Fair Labor Standards Act, or the FLSA, our federal wage and hour law. Actually, let's talk about one key aspect of the law, personal liability. What do you think? Can a CEO or a business owner or even a manager be held personally liable for violating the FLSA? If you said yes, you would be correct. It may not happen all that often, but it is explicitly allowed for under this law. Of course, the individual in question would have to meet the law's definition of employer for this to apply. A case out of the Second Circuit Court of Appeals, with jurisdiction over Connecticut, Vermont, and my home state of New York, gives us guidance on this somewhat confusing question. In this case, current and former managers sued a grocery store chain along with several of its senior executives, including the CEO, claiming that they had been misclassified as exempt employees, a common problem, by the way, and were entitled to overtime for all of their hours worked over 40 hours in a work week. The employees won their claim, but had trouble getting paid by the company, so they tried to collect from the CEO, who, not surprisingly, claimed that he was not an employer, that he only made symbolic or generalized decisions that didn't directly impact the managers. The court didn't buy this argument. They determined that the CEO was an employer for purposes of the FLSA. How did they come to this conclusion, you ask? Well, great question. To be considered an employer under the law, the individual must possess functional control over a company's actual operations and directly affect the nature and conditions of employment. In this case, the court found that there was no question that the CEO had functional control over the operation as a whole. Some of the facts that the court relied upon include: the CEO had regular contact with the stores, its employees, customers, and vendors. He was involved in merchandising and addressing customer complaints. He was involved in the hiring of managers as well as their promotions. He even had overall financial control of the company, including employee compensation, such as signing off on their paychecks. This sounds like an employer to me, at least under the FLSA's definition of an employer. Employers, make sure that your employees are appropriately classified and then that you pay them appropriately. This will help to avoid this problem altogether. Also, make sure that your managers are aware of their role in compliance, because if they have influence over or direct involvement with employment matters, they too could be held personally liable for a violation of the law. I'm Lisa Yankowitz, and that's what you need to know today.